Continue on.
Penal Code, Section 36.05, Tampering with Witness. Statutory provision. A person commits an offense if, with intent to influence the witness, he offers, confers, or agrees to confer any benefit on a witness or prospective witness in an official proceeding, or coerces a witness or prospective witness in an official proceeding. 1. To testify falsely. 2. To withhold any testimony, information, document, or thing. To elude legal process, summoning him to testify or supply evidence. To absent himself from an official proceeding to which he has been legally summoned, or to abstain from, discontinue, or delay the prosecution of another. A witness or prospective witness in an official proceeding commits an offense if he knowingly solicits, accepts, or agrees to accept any benefit on the representation or understanding that he will do any of the things specified in subsection A. It is a defense to prosecution under subsection A5 that the benefit received was reasonable restitution for damages suffered by the complaining witness as a result of the offense, and a result of an agreement negotiated with the assistance or acquiescence of an attorney for the state who represented the state in the case. An offense under this section is a felony of the third degree, except that the official proceedings is part of the prosecution of a criminal case. An offense under this section is the same category of offense as the most serious offense charged in that criminal case. Notwithstanding subsection D, if the most serious offense charged is a capital felony, an offense under this section is a felony of the first degree. Notwithstanding subsection D, if the underlying official proceeding involves family violence as defined by section 171.004 Family Code, an offense under this section is the greater of a felony of the third degree, or the most serious offense charged in the criminal case. Notwithstanding subsections D and E-1, if the underlying official proceeding involves family violence, as defined in Section 71.004 Family Code, and it is shown at the trial of the offense that the defendant has previously been convicted of an offense involving family violence under the laws of this state or another state, an offense under this section is the greater of a felony of the second degree, or the most serious offense charged in the criminal case. For the purpose of subsection A, a person is considered a coercee.
Considered to coerce.
It's considered to coerce, a witness or prospective witness. Coercee. Sorry. Dude, so stupid. Sorry. For purposes of subsection A person is considered to coerce a witness or prospective witness if the person commits an act of family violence as defined in Section 71.004 Family Code, that it is perpetrated in part with the intent to cause the witnesses or prospective witnesses unavailability or failure to comply, and the offense is punishable under subsection E-1 or E-2 as applicable. If conduct that constitutes an offense under this section also constitutes an offense under any other law, the actor may be prosecuted under this section, the other law, or both. Elements. With intent to influence a witness, the person offers, confers, or agrees to confer a benefit on the witness or coerces the witness to testify falsely, withhold anything, elude process, absent himself from official proceeding, or abstain from or delay prosecution of another. A witness or prospective witness is an official proceeding commits an offense if he knowingly solicits, accepts, or agrees to accept any benefit on the understanding that he or she will do one of the above. Restitution and bargains negotiated with investigators are exceptions to prosecution for abstaining or delaying prosecution. An offense is a second or third degree felony. However, if the tampering occurs in a criminal case, the degree of offense is the same as the most serious charge in the case, with the exception of capital cases, in which case the offense is a first degree felony. Penal Code Section 36.07, Acceptance of Honorarium. Statutory provision. A public servant commits an offense if the public servant solicits, accepts, or agrees to accept an honorarium in consideration for services that the public servant would not have been requested to provide but for the public servant's official position or duties. This section does not prohibit a public servant from accepting transportation and lodging expenses in connection with a conference or similar event in which the public servant renders services, such as addressing an audience or engaging in a seminar, to the extent that those services are more than merely perfunctory, and from accepting meals in connection with such an event. Transportation, lodging, and meals described in subsection B are not political contributions as defined by Election Code Title 15. An offense under this section is a Class A misdemeanor. Elements. The person solicits, accepts, or agrees to accept an honorarium for services that the public servant would not have been requested to provide, but for the public servant's official position or duties. Exception. Transportation and lodging expenses in connection with the conference or similar event in which the public servant renders services, such as addressing an audience or engaging in a seminar, to the extent that those services are more than merely perfunctory. Meals in connection with such an event, transportation, lodging, and meals are not considered political contributions. TEC Guidelines. The Texas Ethics Commission has issued several opinions about this section. Generally, they say that a violation depends on the intention of the person who is asking the official to perform the service. If the official is being paid because his or her skills and abilities, such as to teach a course as a subject matter expert and expert, and not because of his or her office, this section is not violated. However, if the only reason the official is being paid for services is that the official holds an official position, the section is violated. Penal Code Section 36.08. Gift to public servants by persons subject to his jurisdiction. Statutory provision. A public servant is an agency performing regulatory functions or conducting inspections or investigations, commits an offense if he solicits, accepts, or agrees to accept any benefit from a person the public servant knows to be subject to regulation, inspection, or investigation by the public servant or his agency. A public servant in an agency having custody of prisoner commits an offense if he solicits, accepts, or agrees to accept any benefit from a person the public servant knows to be in his custody or the custody of his agency. A public servant is an agency carrying on civil or criminal litigation on behalf of government, commits an offense if he solicits, accepts, or agrees to accept any benefit from a person against whom the public servant knows litigation is pending or contemplated by the public servant or his agency. A public servant who exercises discretion in connection with transactions of government commits an offense if he solicits, accepts, or agrees to accept any benefit from a person the public servant knows is interested in or likely to become interested in any contract, purchase, payment, claim, or transaction involving the exercise of his discretion. A public servant who has judicial or administrative authority, who is employed by or in a tribunal having judicial or administrative authority, or who participates in the enforcement of the tribunal's decision, commits an offense if he solicits, accepts, or agrees to accept any benefit from a person the public servant knows is interested in or likely to become interested in any matter before the public servant or tribunal. A member of the legislature, the governor, the lieutenant governor, or a person employed by a member of the legislature, the governor, the lieutenant governor, or an agency of the legislature commits an offense if he solicits, accepts, or agrees to accept any benefit from any person. A public servant who is a hearing examiner employed by an agency performing regulatory functions and who conducts hearings in contested cases commits an offense if the public servant solicits, accepts, or agrees to accept any benefit from any person who is appearing before the agency in a contested case, who is doing business with the agency, or who the public servant knows is interested in any matter before the public servant. The exception provided by Section 36.10b does not apply to a benefit under this subsection. An offense under this section is a Class A misdemeanor. A public servant who receives an unsolicited benefit that the public servant is prohibited from accepting under this section may donate the benefit to a governmental entity that has the authority to accept the gift, or may donate the benefit to a recognized tax-exempt charitable organization formed for educational, religious, or scientific purposes. Elements. Applies to a public servant and an agency performing inspections, solicits, accepts, or agrees to accept a gift from a person subject to inspection, investigation by servant or agency. Public servant with discretion over contracts or payments solicits, accepts from person interested or likely to become interested in contract or payment. Public servant on tribunal or who enforces tribunal's decisions solicits, accepts from person interested in matter before the tribunal. Exception. The public servant may donate an unsolicited item to a governmental entity that has authority to accept the gift or to a non-profit agency. Penal Code Section 36.09, offering gift to public servant. Statutory provision. A person commits an offense if he offers, confers, or agrees to confer any benefit on a public servant that he knows the public servant is prohibited by law from accepting. An offense under this section is a Class A misdemeanor. Elements. Person offers a gift to a public servant. The person knows the public servant is prohibited by law from accepting it. Penal Code Section 36.10, non-applicable statutory provision. Sections 36.08, gift to the public servant, and 36.09, offering gift to public servant, do not apply to a fee prescribed by law to be received by a public servant or any other benefit to which the public servant is lawfully entitled or for which he gives legitimate consideration in a capacity other than as public servant. A gift or other benefit conferred on account of kinship or a personal, professional, or business relationship independent of the official status of the recipient. A benefit to a public servant required to file a statement under Chapter 572 Government Code or a report under Title 15 Election Code 1 that is derived from a function in honor or appreciation of the recipient if the benefit and the source of any benefit is excess of $50 is reported in the statement, and the benefit is used solely to defray the expenses that accrue in the performance of duties or activities in connection with the office which are non-reimbursable by the state or political subdivision. A political contribution is defined by Title 15 Election Code. A gift, award, or memento to a member of the legislative or executive branch that is required to be reported under Chapter 305 Government Code. An item with a value of less than $50, excluding cash, or a non-negotiable instrument as described by Section 3.104 Business and Commerce Code. An item issued by a governmental entity that allows the use of property or facilities owned, leased, or operated by the governmental entity. Transportation, lodging, and meals described by Section 36.07b, or complimentary legal advice or legal services relating to a will, power of attorney, advance directive, or other estate planning document rendered to a public servant who is a first responder, and through a program or clinic that is Chapters 36 and 39 Penal Code, operated by a local bar association or the State Bar of Texas, and approved by the head of the agency employing the public servant if the public servant is employed by an agency. Section 36.08, gift to public servant, does not apply to food, lodging, transportation, or entertainment accepted as a guest, and if the done is required by law. What? That doesn't even make sense.
What page are you on?
62. B at the very bottom. If the done is required by law to report those items reported by the done in accordance with the law, that makes no sense.
It is what it is.
Section 36.09, offering gift to public servant, does not apply to food, lodging, transportation, or entertainment accepted as a guest, and if the donor is required by law to report those items
Maybe that's
reported by the
donor.
donor in accordance with the law.
Maybe that's what they were trying to say, is donor
Donor.
instead of done.
Yeah, if the donor is required by law to report those items reported by the donor in accordance with the law. Section 36.08, gift to public servant, does not apply to a gratuity accepted and reported in accordance with Section 11.0262 Parks and Wildlife Code. Section 36.09, offering gift to public servant, does not apply to gratuity that is offered in accordance with Section 11.0262 Parks and Wildlife Code. Lord have mercy. What does this have to do with property appraisal?
If you are in a public servant position, all these things that they're listing, you could inadvertently do, or depending on your character, you can do on purpose.
In this section, first responder means a peace officer whose duties, including responding rapidly. Stop it. Stop it. You might as well pause it because it's going to stink.
Has the fear passed?
Will you go shut our bedroom door and let the dogs in? I'm sure it's cold for them. That's why Pepper keeps barking.
Okay. Yeah, go ahead.
In this section, first responder means a peace officer whose duties include responding rapidly to an emergency, fire protection personnel, and as that term is defined by Section 419.021 Government Code, a volunteer firefighter who performs firefighting duties on behalf of a political subdivision and who is not serving as a member of the Texas legislature or holding a statewide elected office, an ambulance driver, or an individual certified as emergency medical services personnel by the Department of State Health Services. Elements. This section lists types of gifts that do not violate Section 36.08 or 36.09. Fee prescribed by law. Benefit to which the person is legally entitled or for which the person gives legitimate consideration. Item conferred on account of relationship independent of official status. Political contribution. Certain benefits that an elected official would be required to report under the government code or election code. Non-cash item valued at less than $50. Item issued by the governmental entity to allow use of its facilities or property. Food, lodging, transportation, entertainment accepted as guest. Complimentary legal advice. Penal Code Section 39.02, abuse of an official capacity. Statutory provision. A public servant commits an offense if, with intent to obtain a benefit or with intent to harm or defraud another, he intentionally or knowingly violates a law relating to the public servant's office or employment, or...
Stop. Stop. Is that 7?
Yeah.
Okay.